Thank you, my lord. We've looked at Gmail, and now we're going to look at Skype, which was decided around the same time, but in the opposite direction. And it's Authorities Bundle 4, tab 38. And I take this quite briefly, as it doesn't really add much to Google, other than we see again the same approach taken to the test. And the facts are on page 997. And the court may well be familiar with the Skype product, which is a voice over internet product, like a calling product using the internet. But this was about something
also part of history these days.
I think it is literally now no longer available. And this was about a service, you can see it paragraph 8 on 997, called Skype Out. And the important feature of Skype Out was you could call from the computer to an ordinary telephone, not just computer to computer. And so it said, if you look at the fourth line, it allows users to make calls from a terminal to a fixed or mobile telephone line using Internet Protocol, VoIP. And at 9, it says this again is an over-the-top service. But at 11, importantly, the use of Skype requires an internet connection and the involvement of a telecommunications service provider who can terminate calls on the PSTN, which in other words means ordinary telephones, fixed or mobile. And Skype Communications has entered into agreements with them whose involvement is paid for by the latter in the form of termination fees. So it was a cocktail, and the court found it was sufficient to fall within the scope, unlike Google. And we can see at page 999, paragraphs 24 to 26, it applies the same rubric about the test. Positive and negative, first and then second. And the content exception wasn't actually in play. And then we can probably just cut to the chase. And it says, I'll just try and do this quickly because that's really the only point I wanted to take from it. Page 1001, it makes the point that although it's true, this is paragraph 34, I'm so sorry, 34, although it is true at the technical level, transmission of voice calls made through Skype Out is in practical terms first by the ISPs on the internet, the first segment going from internet connector and the user to the gateway to the PSTN, second by the telecommunications service providers on the PSTN, the second segment going from that gateway to the mobile and fixed connection point. The fact remains such transmission occurs pursuant to agreements between Skype Communications and those telecommunications service providers, and it could not be made without those agreements. And again in 35 it says, it is those agreements that make the PSTN technically possible and guarantees the subscribers the VoIP service by Skype Out. And again at the 40, it said this made Skype responsible for the VoIP service. And that was enough to bring it within. So it's on the other side of the line from the Gmail test, but the same approach, the definition is used. And I want to contrast that to the way the point is summarised in Ofcom's skeleton, which is indeed an accurate encapsulation of the case. And this is in Core Bundle 5, tab 6, page 63. Sorry, it's tab 6, it's not tab 5. Core Bundle, tab 6, page 63. And it's paragraph 59, and it's a conclusory paragraph. And of course, Mr. Holmes will develop his argument. But he says that the tribunal was correct in finding that 32.2 and 2a consist of two conditions and an exception. But then it says the conditions are, 1, it must be an ECN, 2, falls within specified types. The exception is, it does not constitute an ECS insofar as a content service. And then it's really the next sentence, of course, is the difference between us. The tribunal was correct, therefore, in applying the content exclusion and excluding all aspects of the pay CV service related to content before focusing on the aspects of the service implicated in the conveyance of signals. And I draw attention to that simply because it is at odds with the way the services are enumerated in those two judgments that I have just shown you. And also, I'm going to show you the same point arising with, if I may respectfully say, even greater clarity, in a report from the EU committee called BEREC. And BEREC is a committee of expert national regulators, such as Ofcom, established under EU law. So it has its own base, it's based in a regulation, and it exists to ensure the consistent implementation of the common regulatory framework. It's there both to advise institutions themselves and the member states. And until Brexit, Ofcom was, of course, part of it. No longer is. And of course, its views are not binding on this court. I'm not suggesting they are. But I do suggest and respectfully submit that it is informative to look at what the views were of this committee of expert regulators. In case it's helpful, the current BEREC regulation governing its functions is in the bundle under tab 29. But I won't go to it unless you'd find that to be of assistance. But what I will do...
But it's a statutory body.
It's a statutory body under EU law. In fact, perhaps in light of your Lordship's question, I want to just make sure there's no doubt about it. If we go to Bundle 3, tab Authorities Bundle 3, tab 29, what you have here is actually the 2018 version of the BEREC regulation, which would have been made at the time of the EECC. The one that governed the period of the CRF isn't in the bundle, but is materially the same. And if you would find it of assistance, we can, of course, supply copies. But if we look on page 734, recital 5, it says, BEREC and the office, by which it means was established by Regulation 1211/2009 of the Parliament and Council. The last three lines, BEREC acts as a forum for cooperation among NRAs, national regulatory authorities such as Ofcom, and between NRAs and the Commission in the exercise of the full range of their responsibilities under the Union regulatory framework. BEREC was established to provide expertise and act independently and transparently. And then if we go to the operative part of the regulation, page 742, Article 3 states its objectives, which are indeed set out in some other legislation. But you'll see in Article 3.2, BEREC shall aim to ensure the consistent implementation of the regulatory framework for electronic communications. BEREC shall carry out its tasks independently, impartially, transparently, and in a timely manner. BEREC shall draw upon the expertise available in the national regulatory authorities. On the next page, regulatory tasks of BEREC to assist and advise the NRAs, the European Parliament, the Council, and the Commission, and cooperate with the NRAs and the Commission upon request or its own initiative on any technical matter regarding electronic communications within its competence. And then finally, page 749, Article 7, composition of the Board of Regulators. The Board of Regulators shall be composed of one member from each member state. Each member shall have the right to vote. Each member shall be appointed by the NRA that has primary responsibility for overseeing day-to-day operation of the markets for electronic communication network and services. And that, of course, is Ofcom.
Would it be fair to say it's a statutory body whose views, whilst not binding, are persuasive?
I would submit so. I mean, they're entirely consistent with our submissions, and that's the highest I put the point. It's corroboration, my lord, is how I put it. And I'm helpfully told office, when I read out office in Article 1.1, means the agency for support of BEREC.
So that's the statutory basis of BEREC, and you're taking us to the BEREC report.
I am. And I'm going to take you to one, although in fact we have two in the bundle, and it's an A446. And just to show you both, this is
tab 46.
Tab 46, and it's page 1077. And this is a report on OTT services dated January 2016. So this is before the adoption of the EECC. And tab 47 is another report from around the same time on the Internet of Things. But they say similar things, and I'm not going to take your time with both. But we'll look at the OTT services report, if we may, please. And if we go to page 3, what this report is really about is saying how should the existing definition be applied to OTT services? And it concludes the answer is it's not easy, and it proposes there should be reform. And if we look at the third paragraph, it says OTT is a term frequently used but often not clearly defined. Some use this term to define a group of actors, others to qualify a category of services. In this report, BEREC defines an OTT service as content, a service or an application provided to the end user over the public internet. Now, I laboured the word content because they're obviously thinking about something here that can contain content. And then it says this means the OTT does not refer to a particular type of service, but method of provision. And then it breaks them down into different types of OTT, but I don't think we need to trouble ourselves with that. And then it says at the bottom of the page, due to the current and expected evolution of new services taking place online, the boundary between ECSs and the content services provided over electronic communication networks, the latter outside the scope of the regulatory framework, becomes more and more blurred. While the ECS definition, elaborated in a different moment of technical evolution, with internet-based services at a very early stage, has served its purpose in the context of traditional services, it poses challenges in the OTT environment, as it is unclear to what extent the current ECS definition covers some types of OTT services. Different conclusions can be drawn whether specific OTT services are qualified as ECS. This is also reflected, for example, with regard to OTT voice services that have the possibility to make incoming or outgoing calls to the public available telephone service. In other words, Skype. So they're worrying here about the applicability of the definition of ECS to the newly evolved OTT services that weren't really envisaged in 2002. And we've seen from Skype and Google that these worries were well-founded. And over the page at 180, it makes its recommendation, the second paragraph. In BEREC's view, the definition of ECS should be clarified and or reconsidered in order to ensure it keeps pace with current technological developments, that it is future-proof and it is still the correct foundation that determines which services are regulated under the ECNS framework. The lack of clarity in the definition opens the door to different interpretations that reduce the harmonisation between member states and provide uncertainty to providers in the market or those that consider entering it. And of course, my Lord Justice Green talked about exactly that issue this morning. And we've also seen this morning that, in fact, in 2018, the directive was changed and definitions were introduced of interpersonal communication services and internet access services that did provide clarity in this area. But the report goes on and analyses how the definition of ECS applies as then current, in other words, 2016 CRF version. And if we look at page 1083, please, it explains what the aim of the report is. The BEREC report provides an analysis of OTT services, their definition, and their impact on the electronic communication services, both in terms of competition and consumer protection, as well as their impact on the EU regulatory framework. This report is focused on the relation between OTT services and ECSs. So it acknowledges that those interests of competition and consumer protection are in play, and it looks at these issues with some care. But I needn't take your time up with too much more of this. If we could turn, please, to page 1087, we can see that the definition of ECS from the Framework Directive is set out. and that, of course, is the 2016 version with underlining. And then Berek says, with the previous definition, there are 3 basic criteria. An ECS should normally be provided for remuneration, consists wholly or mainly in the conveyance of signals, excludes services providing or exercising editorial control over content. So it breaks it down into 3, quite similar to what we saw in the subsequent judgments of the European Court. Although this definition has been transposed by all member states in equal or very similar terms, these criteria are nonetheless interpreted differently by the NRAs when assessing whether specific types of service qualify as ECS. The analysis of the interpretation of these criteria is focused on the first 2, the third being a negative one that excludes services providing content, but does not indicate which services are qualified as ECS. Now that is only the view of Berek, but it is antithetical to Ofcom's analysis. Ofcom's analysis, of course, is that the order of these should be 1, 3, 2, not 1, 2, 3, and that the content does indeed indicate which services are qualified as ECS.
The last sentence there, but does not indicate which services are qualified as ECS, is that inconsistent with Ofcom's?
Well, I would respectfully say it is, because it's basically saying that the first 2 answer the question, and the third one doesn't answer the question which services are qualified as ECS. That's the gist of what it says.
But it does on your case.
No,
Because you can only
not absolutely not, my lord.
whether you qualify as an ECS by looking at the proportion of content.
We look at the proportion of a conveyance, my lord. It's a really important distinction. On our case, you ask, is the service as a whole wholly or mainly the conveyance of signals? Ofcom's case is you start by saying which part of it is content, and then you remove the content before you apply the proposition at number 2 of this Berek enumeration.
But the way you put it involves also looking at how much of the service is content in order to
that sense,
determine
that's right.
whether it's wholly or mainly.
But that's simply
transmission.
because you apply the wholly or mainly test in number 2, and the minority element is in fact content.
Well, I understand your case, but saying that this is consistent with your case and inconsistent with that of Ofcom seems to me to ignore what's said at the end, which is that the content exclusion does not indicate which services are qualified as ECS.
Well, my lord, my submission at least, perhaps it's not finding favour, is that it is on Ofcom's case that the content exclusion becomes of critical importance in identifying which services are ECS, because it's knocked out first.
I get that. And actually, the 1, 2, 3 supports your argument. It's the way they then apply it, which really means they're saying 1, 3, 2.
Well, I respectfully would accept that.
Because the content doesn't tell you what's an ECS. That's because you apply it first, and then you have another stage, which is wholly or mainly. How can it, on your analysis, it has to give you the answer, but it doesn't. I mean, I think this, maybe said this is just loose drafting.
Well, my lord, you have my submission. I hear what you say, but the way we would characterise this is that 1, 2, 3 is the correct order. As per
But how does that not tell, on their analysis, if that's correct, why do you not get to the answer at the end of the day that something is or is not an ECS on this analysis here? Because they say it doesn't indicate.
Well, indeed, but what I'm submitting is that it's on Ofcom's case that it becomes critical to know whether it's content before you apply the wholly or mainly test.
Yes.
Here you apply it at number 2, and then you exclude the content at number 3. That's precisely what we're saying.
But that then would tell you what an ECS was, when they say it doesn't. Yeah.
Well, no, because what tells you what it is what tells you whether it's an ECS is number 2.
Okay. The question is whether it's a regulatable ECS or not.
Exactly. That's the point. And then the number 3 says you then exclude services providing content. That's our submission. In our submission, this is supportive of our analysis and contrary to Ofcom's, which puts number 3 at either number 1 or number 2.
Why do you say that it then requires number 3? What's the basis of saying this is providing an order in which you apply the test?
Then it's thirdly.
Is that it?
That's it. And then it says the analysis of these criteria is focused on the first 2, The third being a negative that excludes services but does not indicate which are qualified as ECS. What I'm submitting is it's 1 and 2 that indicate which services are qualified as ECS.
You're reading them as sequential, and of course they could just be read as, you know, you have to do 1 and 2, but along the way
It could
you
be.
do the exclusion.
My lord, it's not a statute, I fully accept. That's the way we read it.
No, I see.
But then I want to take you to another passage which is also important. And this is at page 1089. And this goes to the points my lord was making to me this morning about the difficulty of the exercise faced by Ofcom. And you'll recall that my submission was, sometimes it will be difficult, sometimes it will be easy.
Yeah.
And we can see mainly picked up in the 4th paragraph. Regarding the 3rd issue of the interpretation of mainly, the following considerations can be made. When the service does not consist wholly in the conveyance of signals, the definition of ECS implies the elements of the service that are conveyance and for which the provider is responsible should be weighed against the elements that are not conveyance. However, the relative importance of conveyance within a service compared to non-conveyance requires judgment from the regulator, qualification as against mere quantification. In this judgment, several factors can be relevant, among which technical and/or functional characteristics, demand-side related aspects such as end-user perspective with regard to contractual responsibility of the OTT provider vis-à-vis the end user. And of course, you heard me make these points this morning. Such an assessment can be done in different ways, leading to narrower and broader interpretations of the definition of ECS. The narrower interpretations of ECS are those asking for more stringent requirements regarding the relative weight of the conveyance of signals for which the provider is responsible than the broader interpretations require. In Barek's view, there is considerable difficulty in applying the mainly criterion, since it's not usually possible to quantify the amount of conveyance and non-conveyance. Some OTT providers are responsible for the part of the network end-to-end transmission path, and therefore responsible for some conveyance of signals. And then it concludes at 3.2.3, the regulatory framework does not provide clear-cut guidance. And I draw your attention to that simply to say that the sort of observations my lord made this morning were obviously of concern to Barek as well. And then what happened after this is that the regulatory framework was revised and the wholly or mainly test was not applied to all categories, but it was applied to the one that we're interested in. So this is an acknowledgement that that calls for difficult regulatory judgments, but the regulator stayed with that test.
This is in the context of conveyance of signals. I mean, this is tech v tech evaluation, isn't it?
It is,
Yeah,
but
in that context, they're saying it may involve difficulties in making that judgment. But that's not quite the same as meeting arguments about the difficulty of making a judgment about content versus...
It's a different judgment, my lord. I fully accept that. And I really go to it just to make good the submission I made this morning, that this wholly or mainly test is bound to involve evaluative judgments. That's the point.
I'm sure Ofcom loves that. The more evaluative, the less challenging.
Well, they've been heard to say it in this court many times. Mr. Holmes himself has probably said it in this court many times.
He has.
So I do accept that the weight that can be placed on this is limited, but we do respectfully submit this is of assistance. And with that, what I was going to do was go to my final head of submissions, where I seek to draw all of this together again. And we go, if we could please, back to the 2003 Act in Authorities Bundle 1 under Tab 2. And we've seen that there are some, page 19, I'm sorry, section 32. And we've seen that if we look at the definition of electronic communication service, there are differences undoubtedly to the EU regime. The word partly is used instead of wholly or mainly, but the structure of it is equally reflects the division of 3 different types of service and the same carefully calibrated approach. The number-based interpersonal communication service is not qualified by the requirement that it be exclude matters that are ancillary. There is some complicated implementation of that, and Mr. Holmes will explain if it's of help to you. But I don't make a point about that. But what I do say is that we have A, B, and C, wholly or mainly only in C. Yep. But according to Ofcom, the content question has to be read into both A and B. So if you think about B, even A or B, it would become important to know whether there was content before applying these tests, A and B, even though neither of them has a qualification on this form of implementation. What we say, as you've heard me say, is the words "except so far as it is a content service," they're rightly included. They reflect the fact a service might be partly content, but their purpose is to ensure the broad powers in the Act are not used to regulate content. And I showed you earlier at page 38, section 51A, in principle, on its face, protecting the interests of end users, one could imagine being used to regulate, for example, the content of programming or of advertising. But this, we respectfully submit, would be the wrong approach. Ofcom's analysis of section 32, in effect, rewrites the carefully calibrated gateways set out in section 32.2a in the interests of consumer protection. We don't challenge the value of consumer protection, but a generalised plea of that kind cannot override this carefully calibrated statute. And unless the court has any more questions, those are my submissions.
Well, thank you very much indeed. That's most helpful.
Thank you.
Mr. Holmes.
Good afternoon, my lords. I propose to address you on three matters. The first is the text of section 32. We say that it accords better with the tribunal's and Ofcom's view of the section. Second, we say that the tribunal's interpretation is supported by the particular context and purpose of section 32. Under that head, there are 2 points to make. The section 32 was introduced in order to implement the Electronic Communications Code, and the starting point is the text of the Communications Code, which Mr. Ward took very lightly, and he didn't show you words which we say are very significant and which confirm the interpretation that was adopted by the tribunal. In Article 2, paragraph 4 of the Code, the definition of ECS expressly provides that the wholly or mainly test should be applied to a service with the exception of its content element. The text of the Communications Code therefore resolves any ambiguity that there might otherwise be in how section 32 should be applied. Now, Mr. Ward sought to avoid that or anticipate it by saying that the EECC reflects the same test as has always applied in the common regulatory framework which preceded it. But the text remains relevant. It shows how the legislature understood that test to work, and we say that it confirms the tribunal's interpretation. I'll show you that by reference to the words of the Code. We say that the definition of Article 2, paragraph 4, in Article 2, paragraph 4 of the Code, in turn accords with the underlying purpose of the European legislation. A key aim reflected in the preamble of both the Code and its predecessors is to bring the transmission element of broadcasting networks within the regulatory framework applicable to communications services. The stated intention is to achieve the parallel operation of two regulatory frameworks, each governing their respective elements of the unified service: content regulation for the content element and communications regulation for the transmission element. And that, we say, is consistent with a philosophical distinction between regulation of content and regulation of transmission. They simply operate in different spheres. On a correct approach, it's therefore not a question of counting up content elements and, if they prevail, ousting transmission regulation. Instead, there are parallel regulatory regimes reflecting very different considerations, scope, and purposes. We say that the tribunal's interpretation is consistent with that. Sky's interpretation is inconsistent with it. On Sky's approach of applying the wholly or mainly test to the whole service, including the content element, that content element will eclipse the transmission element in the case of a unified service like Sky's, as the tribunal found at paragraph 148 of the judgment. And the result is to remove broadcasting transmission services from communications regulation. This defeats the intention of bringing such transmission services within the scope of communications regulation, and there is no good reason for it. The effect of Ofcom's interpretation is not to deprive the wholly and mainly test of purpose, as Mr. Ward suggested. That test ensures that the application of regulation to transmission is proportionate. If the transmission element of a combined service is minor after the extraction of any content element, it will not fall under regulation. And an example would be precisely Sky's OTT service. This is pay TV content carried over the open internet. In that situation, it was common ground that below, and it was accepted by the tribunal, that the service did not qualify as an ECS, applying a tech-on-tech balancing. As Lord Justice Green canvassed with my learned friend, Ofcom's interpretation also accords better with legal certainty because it will be much more straightforward to work out whether any given service is to be caught or not, the tech-on-tech balancing. It does not raise intractable questions about whether in a pay TV service, the content service element is the main element, or what content should be counted towards that. That's avoided, and it leads to a more straightforward and certain application of the test. So starting, if I may then, with the text of section 32, if we could turn that up again, please. It's in the Authorities Bundle, volume 1, at tab 2, page 19. And we make 3 points about it. The first concerns subsection 2. It defines an ECS as a service of a type specified in subsection 2A, except so far as it is a content service. The it, therefore, clearly referring to the service that is being assessed. And we say that the natural and ordinary meaning of this provision...
So it refers to any or each of A to C.
It refers to this, in my submission, it refers to the service that is being considered. So a service which you then look to see whether it falls with any of the within any of the types after excluding the content element. But the it is the service.
And it could be,
under
A and or B and or C.
And any of those, once you come to consider
yes,
which of those it falls under. And I'll address you on whether that presents any difficulty. We say it doesn't. So we say that the natural and ordinary meaning of subsection 2 is that the service is to be assessed under subsection 2A with the exception of any content service that it includes. That reading ties the content exception into the process of defining an ECS, consistent with its placement in the Act as part of the definition. On Sky's interpretation, by contrast, the content exception comes into play later. It plays no role in identifying whether a service is an ECS in principle in relation to at least certain of its activities. Instead, it applies only after a service has been found to constitute an ECS and serves to delimit the substantive scope of the obligations to which the ECS will then be subject. And we say that interpretation is difficult to reconcile with its placement in the definition. The second point on the text concerns the types of service identified in subsection 2a, and paragraph C is the most relevant for present purposes. It applies to a service consisting in or having as its principal feature the conveyance of signals. That's the so-called wholly or mainly test. The provision then identifies a transmission service used for broadcasting as one of two specified examples of such a service. And we say that this is again consistent with the tribunal's interpretation. On the tribunal's approach, a broadcasting transmission service is very likely to be caught by the wholly or mainly test. And that is because the content element of the service is accepted from the assessment. On Sky's approach, however, a broadcasting transmission service is unlikely to be caught in the case of any service, like Sky's, where it is provided together with the content being transmitted, given that the content element will typically predominate over the carriage. One need only consider the qualitative criterion suggested by my learned friend. What does the user attach value to? If you asked a user what they attach value to in a pay TV service, I think they would say probably the pay TV that they watch. If Sky were right, a transmission service for broadcasting would be an odd inclusion in subsection 2a, paragraph B. A broadcasting transmission service would in that case not be paradigmatic of a service consisting wholly or mainly in the conveyance of signals. It would be caught only if it were provided separately from the content that was carried. The other two subparagraphs in section 32, subsection 2a, are, we say, also compatible or consistent with the tribunal's interpretation. They are an internet access service and a number-based internet interpersonal communication service. The function of both those services is the carriage or conveyance of a communication, transmission, either internet-based content or interpersonal communications, calls to or from a telephone number. They show that the focus of subsection 2a generally is on the service of carrying or conveying content considered separately from the information or content that is being carried. And we say that neither of those services presents any difficulty for the tribunal's interpretation. Each will be caught whether content is excluded prior to the subsection 2a assessment or not. They're therefore neutral as between the interpretations that are presented before you. The third relevant element of the definitions is section 32, subsection 7, defining a content service. It specifies that a content service means so much of any service as consists in one or both of the following: the provision of material with a view to its being comprised in signals conveyed by means of an electronic communications network, and the exercise of editorial control over the contents of signals conveyed by means of such a network. Now, we say that this can only be read as capturing both content that is subject to editorial control and the provision of content, the editorial control of which is exercised by someone else, by a third party. Otherwise, subsection 7a would be otiose. It would serve no purpose. And you see that...
Well, it doesn't say where the material has come from.
It doesn't say where the material has come from, but it's clear that these are alternative types of content service.
But it could either be generated in-house or it could be acquired in from a third.
It could, but if it were generated in-house, one would suppose that there was editorial control over it. by the party producing it. So as we read subsection 7, it covers both the production of content, in relation to which editorial control will be exercised, or the provision of third-party content. And that shows the breadth of the exclusion that is likely to be affected by Sky's interpretation. If you include the content element when you come to apply the wholly or mainly test, and if you accept that content services include not only content produced by the provider, but other channels carried by the provider, but produced by others, it's very difficult to conceive of a circumstance in which the wholly or mainly test would ever be met in the case of broadcasting transmission services. They will always be involved in the carriage of content, and the carriage of content is very likely, if not necessarily, going to be the predominant element. That would be true whether you considered cost. It would also be true if you looked at what the user values, because the user will be taking the service to watch the content.
I'm not sure you could divide them at all. If content service is the provision of the content by the use of signals, then it's very difficult to say that one is any greater than the other.
In my submission, it can be provided once one appreciates and accepts that this whole regulatory scheme rests on dealing with the carriage, the transmission, and that content is laid to one side for the purposes of determining what is to be regulated, the electronic communications service. That is a distinction that can be applied. We say that the alternative interpretation does create intractable difficulties of application because, as your lordship suggests, it would be very difficult to disentangle and consider separately the medium from the message, the content from the means of transmission. So we say that this definition of content is consistent with the tribunal's interpretation. First, we say that subsection 7 involves disaggregating a unified service into its constituent parts. A content service means so much of the wider service as involves the provision or production of content. And
sorry, can I just for my purposes,
of course,
understand that point? So the 32.7 implies that the service in 32.2a, each of those services, does include
content. Yes.
But your submission is it doesn't need to be content provided by the entity that is providing the services in ABC?
It can be content, it is content that is transmitted by, provided by those people, but it is not necessarily produced by those people. That's the distinction I'm drawing. So production involves editorial control. Yeah. Provision involves the carriage of content to the end user, yeah. Which is produced by another party. There's the bouquet of channels which Sky carries, third-party channels that Sky carries to make the point concrete.
Slight difficulty is it's the provision with a view to its being comprised in signals conveyed.
Yes, well...
So is this a pre-step before the signal cuts in, as it were?
Yes.
It is?
Yes.
So it's identifying the content.
So indeed, I was about to pray and aid exactly those words. We say that those words are consistent with the content and the carriage being separate, and the purpose being to isolate content from carriage, because the content is what is provided with a view to its being comprised in signals, and the regulated element is the provision in the signals. And that supports, we say, the sequential approach taken by the tribunal, where you take out content, what is to be provided via the signal, from the act of transmission, which is then assessed under the wholly or mainly test. So that's what we say about the text. We don't say the text is determinative. We agree that this text is could be amenable of different interpretations. But we say when one then comes to consider the underlying European materials, which this text is intended to implement, the tribunal's understanding and reading is very clearly confirmed. And it's to that I want now to turn. If we could, so it's common ground, I think, I don't need to show you this, that the context and purpose of section 32.2 was to implement the European Electronic Communications Code in 2018 into UK law.
Yes.
The legislative intention was to give effect to the code. And the obvious starting place is to look at the text of the code to see how it defines an ECS. And for that, could we go to the code, which is in the Authorities Bundle, Volume 3, tab 30. And the definitions are contained in Article 2 on page 834. So Article 2, paragraph 4 contains the definition of electronic communications service, which section 32 is then intended to implement. It states that an electronic communications service means a service normally provided for remuneration via electronic communications networks, which encompasses, with the exception of services providing or exercising editorial control over content transmitted using electronic communications networks and services, the following types of service. And at C, services consisting wholly or mainly in the conveyance of signals, such as transmission services used, amongst other things, for broadcasting. So taking it...
So you focus on the word encompass. You reverse it and say it doesn't encompass content.
Yes. So I think your lordship has my submission, but just to make sure that I understand your question, we say an electronic communications service as defined here is a service which encompasses, with the exception of content services, the definition of which is included in the provision, the specified types of service. The definition requires a consideration of whether the service, what the service encompasses, with the exception of content services. Once content services have been accepted, one looks to see if the service includes the specific types of service which are then listed. And if, with the exception of content services, the service encompasses services consisting wholly or mainly in the conveyance of signals, it is a service of the right type to qualify as an ECS. So we say Article 2, paragraph 4 is really quite clear. The text of that provision shows that the appropriate order of analysis is to exclude or accept the content services as a first step and to consider whether the service encompasses services consisting wholly or mainly in the conveyance of signals only after one has applied that exception. So does the service encompass, with the exception of content services, the following types of service? C, services consisting wholly or mainly in the conveyance of signals. That is the tribunal's interpretation. So insofar as there were any ambiguity or doubt in section 32 itself, we say Article 2.4 lays it to rest. Consistent with the approach of excluding content first, content services are described in Article 2.4 in contradistinction to electronic communication services. And this, I think, picks up the point that my Lord Justice Zacaroli was making in relation to the equivalent provision of section 32. So looking in the third line, content services are services providing or exercising editorial control over content transmitted using electronic communications networks and services. So in other words, the content service and the ECS are mutually exclusive. The ECS is the means by which the content service is carried. And again, we say that matches the tribunal's interpretation. Whether a service is an ECS is to be assessed with the exception of any content element which it contains, and the content element service will necessarily be separate or distinct from the ECS. And it runs counter to Sky's approach, which leaves the content element in when assessing whether a service is an ECS, such that an ECS could itself partly consist of a content service, if the wholly or mainly test were met. While we're looking in the definitions part of the European Code, can I ask you also to look at the definition of electronic communications network in Article 2, paragraph 1, further up, page 834. The definition of ECS in section 32 and Article 2.4, they both apply to a service provided via electronic communications networks. And one sees from Article 2, paragraph 1, that an electronic communications network is broadly defined to mean transmission systems, including satellite networks, in the fifth line, networks used for radio and television broadcasting in the penultimate line, and cable television networks also in the penultimate line. And we say that this underlines the fact that the legislation is intended to capture and regulate the transmission of content, including in particular the broadcasting of television, and including, as in Sky's case, by means of satellite networks. And that explains why the definition of ECS works by excluding the content element first. It's so that the conveyance element can be isolated and regulated as an ECS. It avoids unified services being arbitrarily excluded from the scope of regulation because their content element predominates. Now, the interpretation which emerges from the text of the code accords with the objectives underlying the legislation as set out in the recitals in the preamble of the European Code. So if we could first consider recital 7 on page 752 of the authorities bundle, it states that the convergence of the telecommunications, media and IT sectors means that all electronic communications networks and services should be covered to the extent possible by a single European electronic communications code. Now, pausing there, the European Electronic Communications Code, and indeed the legislation which preceded it, have as a defining objective to bring the communications networks and services that are used in both telecoms and media, as well as IT, under a single regulatory framework. Those sectors all involve a communications infrastructure used for the conveyance of information, whether that is in the form of interpersonal communications or media content. The legislative intention, as set out very clearly in the first sentence of recital 7, is to apply one common set of rules to the communications networks and services used to convey information of all kinds, whether television, radio, telephone, or internet. And the aim is to bring the transmission element of media services, the media sector, within the framework of regulation applicable to communications providers. The question then arises how the regulatory framework applicable to the communications or transmission side of the business relates to the regulation applicable to content. And the answer is supplied, we would say, in the next sentence in the recital, starting in the 5th line. It states, it is necessary to separate the regulation of electronic communications networks and services from the regulation of content. Therefore, this directive does not cover the content of services delivered over electronic communications networks using electronic communications services, such as broadcasting content and some other examples, and is without prejudice to measures taken at union or national level in respect of such services. So in other words, the EU legislative framework envisages separate and parallel regulatory regimes, one regulating the communications aspect of the relevant industries, and the other regulating content, including broadcast content. Now, the necessary consequence is that a company such as Sky, that provides both content and the communication or transmission of that content, may find itself simultaneously subject to content and communications regulation, covering each element of its service. And turning over page to 753, that is expressly confirmed in recital 11. The same undertaking, for example, a cable operator, can offer both an electronic communications service, such as the conveyance of television signals, and services not covered under this directive, such as the commercialisation of an offer of sound or television broadcasting content services, and therefore additional obligations can be imposed on such an undertaking in relation to its activities as a content provider or distributor in accordance with the provisions other than those of this directive, without prejudice to the conditions laid in an annex to this directive. Now, we emphasise there the word additional. So the obligations that arise in relation to content are additional in the case of these unified service providers to those which apply in relation to the regulation of transmission, which is what the ECS definition captures and what is regulated under the relevant parts of the Communications Act, which deal with ECSs. But it's quite clear from recital 11 that the aim is to have parallel regulation applying at the same time to one of these beasts that unifies content provision and transmission provision. Otherwise, the word additional in that paragraph would make no sense. So in overview, a high-level objective of EU legislation is to apply a single framework of regulation to communications networks and services used in both media and telecoms. And that framework, relating to the conveyance of information, applies separately and alongside rules to regulate content. And we say this design is reflected in the definition of electronic communication services in Article 2.4, which I showed to you, and in Section 32. Article 2.4 clearly excluding content from the assessment of whether a service is an ECS, and focusing instead on whether the service involves conveyance of content, whether it's wholly or mainly concerned with the conveyance of signals. Those definitions isolate that part of the service offered by a provider, the conveyance element, which the communications legislation is intended to bite on, to regulate. To do that, they leave out of account the content element, which is subject to separate and parallel regulation. Conversely, Sky's approach cuts across the broader objective of the legislation. It requires a pay TV service, including communications and content, to be treated as an indissociable whole at the stage of deciding whether it is an ECS or not. If the content element is deemed more important, having regard to its cost or significance to subscribers, or some other ill-defined measure of importance, then this would eclipse the communications or conveyance element altogether. So instead of parallel regulatory regimes applying simultaneously to communication and content, the effect is that the communications element of the service is removed from regulation and only the content side is regulated. And that just does not align with the legislative purpose that I've shown to you of ensuring the regulation of communication services, including in the media and communications industries, applying additional obligations to those that one sees on the side of content to a unified service like Sky's. Sky's approach amounts to saying that content regulation trumps communications regulation wherever the content element of the service predominates. And we say that's clearly not what was intended. While we're in the EECC, can I address a point raised by Lord Justice Popplewell regarding the regulation of unlawful content? This is covered in the case of transmission regulation by the types of general condition that a regulatory authority may apply to a pay TV service. And one sees that on page 863 of the code. So this annex sets out, this is annex, you see at 862, Annex 1 sets out a list of conditions which may be attached to general authorisations, rights of use for radio spectrum and rights of use for numbering resources. So these are general conditions that can apply to ECSs. And if you look at C4 on 863, you see that general conditions can include restrictions in relation to the transmission of illegal content in accordance with a content directive, and restrictions in relation to the transmission of harmful content in accordance with another of the content-based regulatory measures. So, in other words, On the transmission side of a unified service, there are rules within the communications framework that prevent the carriage of unlawful or harmful content. What this legislation doesn't do is tell you what unlawful or harmful content is. For that, unsurprisingly, you look at the other parallel regime of content regulation, which sets out rules about the types of content that can be provided. But this we say is consistent with parallel and separate regulatory regimes working alongside one another in a coordinated manner.
But this directive contains part of that parallel content regulation.
It permits the application of that parallel content regulation to the transmission service, which is what this legislation is intended to bite upon.
There was a question raised this morning as to whether the regulation of content, we don't think we have in the bundles, do we, the details of the regulation, either the statutory source for it or the code of conduct in this country in relation to content.
No.
But the question was, does that apply in any event to the person who's sending the signal, who's conveying the signal?
So I will stand to be corrected by those that instruct me, but I think not. The signal, the signal element of the service is regulated under the framework applicable to ECSs. And the provision I've just shown to you is how the transmission element is controlled to ensure compliance with the separate regulation of content. Yes, I believe that's correct.
There's a certain amount of nodding and shaking going on.
Oh, was there? Well, maybe that I can
Their
catch
heads
up
down.
at a convenient moment. So I'm informed that the broadcasting code, which is one of the places that regulates content, may apply to either the broadcaster in the sense of the person doing the transmitting or the generator. So it is cross-cutting to that extent.
Is this what I had a quick look at what I thought was the broadcasting code? I'm not sure it is, but it talks. It's phrased in passive language. For example, Rule 1.1: material that might seriously impair the physical, mental, or moral development of people under the age of 18 must not be broadcast.
Yes.
Which would, on its face, appear to cover both.
Yes, which I think is consistent with the instruction that I just.
Could we be shown or directed to what?
Yes, of course. Could we?
Correct version.
Yeah.
Can you do that after the hearing?
Yes, of course.
Send us something.
Yeah, we'll do that. We'll let you have the materials.
Make sure your opponents have seen it and agreed
Of course.
in advance.
Yeah, we'll do. Can I now turn to the EU law that applied pre-code? We say that the same picture emerges from the EU legislation that was in place before the code. That's to say the 2002 package of directives known as the new regulatory or common regulatory framework.
This is wholly or partly territory.
Wholly or partly, indeed. No, this is post wholly or partly. The wholly or partly was the 1990
yes,
regime.
quite.
The CRF regime already had
We now have the wholly or
incorporated
mainly.
wholly or mainly.
Yes.
Indeed. But the principles, the purposes and the definition, we say, are both consistent with the approach taken in the code. So the key provision is Article 2C of the Framework Directive, which is Authorities Bundle Volume 3, tab 24, page 596. And it provides that an electronic communications service means a service normally provided for remuneration which consists wholly or mainly in the conveyance of signals on electronic communications networks, including telecommunications services and transmission services in networks used for broadcasting, but exclude, there's a slight grammatical difficulty there, but it's in the French, if it helps, it's which excludes services providing or exercising editorial control over content transmitted using electronic communications networks and services. It does not include information society services. So one sees that the definition aligns closely for present purposes with the definition now included in the code. Content services are excluded in the same way, but transmission services in networks used for broadcasting are expressly included as one of the paradigmatic examples of a service consisting wholly or mainly in the conveyance of signals on electronic communications networks. The tribunal will note also the same two-limbed definition of content services, provision of content and production, exercise of editorial control. And the recitals make very similar statements to those in the code preamble about convergence, the need to separate communications and content regulation, and the potential for rules from each to apply to the same undertaking.
This was recital 5 as opposed to recital 7 of the code.
Yes, indeed. So this is recital 5 on page 587. The first sentence of recital 5 captures the objective of bringing the conveyance element of the media sector within the scope of the new regulatory framework. Exactly the same point as in the code. So all transmissions, networks and services to be covered by a single framework, including those in the media sector. And reading the definitions in section 32 in the light of that purpose, we say that the tribunal's interpretation is to be preferred, separates out the transmission service from the content service, and allows it to be categorised as an ECS, including in cases where it's provided as part of a unified service. Looking down in the recital, the various directives are then identified, and then in the middle of the paragraph, it continues, it's necessary to separate the regulation of transmission from the regulation of content. This framework does not therefore cover the content of services delivered over electronic communications networks using electronic communications services, such as broadcasting content, and is therefore without prejudice to measures taken at community or national level in respect of such services. And the content of television programmes is covered by other legislation. So the emphasis here is on separating out transmission regulation. That is what the new regulatory framework is concerned with. It's about regulating transmission and not content. And that favours considering the transmission element separately and in its own right when defining an ECS. Supports the prior exclusion of content services. And indeed, that point is made explicit in recital 5, which treats content services and electronic communications services as separate and distinct. It's the same point as we saw in recital 7. If you look at how content services are described, they're described as services carried over ECSs. Does not cover the content of services delivered over electronic communications services. So two separate elements. And the example is then given of broadcasting. Again, this would be a very odd example to pick if Sky's interpretation were correct. But all this means, we say, is that the recital firmly supports the tribunal's interpretation as the correct one, in view of the purpose of ensuring separate regulation of transmission in the case of broadcasting services. And the same point emerges particularly clearly from the recitals of the Competition Directive, another part of the 2002 framework. That's Authorities Bundle 3, tab 26, on page 676. I can ask you please to read recital 7 on the right-hand column of the page. And so it's page 676 of the bundle 3, tab 26, page 676. And it's recital 7 of the Competition Directive, which is another of the same package of measures, the new regulatory framework. And we lay particular emphasis on the sentence, thus the transmission and broadcasting of radio and television programmes, this is the final sentence on page 676, the transmission and broadcasting of radio and television programmes should be recognised as an electronic communications service. So an unequivocal statement that transmission and broadcasting of programmes are caught as ECSs. And this makes perfectly clear the intention of the EU legislature in enacting the definition of ECSs, which is implemented in section 32. It was that transmission and broadcasting of radio and television programmes should be caught as ECSs. The Tribunal's interpretation of section 32 achieves that by ensuring that the transmission element is not eclipsed by the content element when assessing whether the service consists wholly or mainly in the conveyance of signals. Sky's interpretation, we say, undercuts the objective by requiring content to be included as part of the assessment, thereby excluding the transmission and broadcasting of many radio and television programmes from regulation as an ECS. We say that the legislative history, insofar as one needs to have regard to it in view of the very clear recitals, also supports our interpretation and not Sky's. Mr. Ward took you to the 1999 Communications Review. That's in Authorities Bundle 4, tab 41. And the key policy proposals begin on page 1032. See the heading at the foot of page 1032, key policy proposals. And then on page 1033, one sees that the aim was to introduce a single regulatory framework for communications infrastructure and associated services. And in the second bullet under that bold heading, the new framework would cover all communications infrastructure and associated services. In practice, this means the new framework would apply to telecommunications networks, satellite networks, cable TV networks, and terrestrial broadcast networks. So confirming that the transmission element was intended to be caught as an ECS. And in the third bullet, these rules would of course be without prejudice to regulatory obligations which apply to the content of broadcasting services. And then a figure setting out a new framework with the communications infrastructure at the bottom, the communications services in the middle, and above the line, the services provided over networks, which are separately regulated, the broadcasting services, that's to say the content. And we say that what this makes clear, the positioning of the line capturing the services below the line, is that services provided over broadcasting networks were intended to be caught, and only the content element was outside the scope. And that's inimical to the idea that content element of the service should, if it predominates, exclude the regulation of transmission. And then what about the situation where a single service provider is engaged in both content provision and transmission, as in the case of Sky? Well, that's briefly covered. We say it's very clearly set out in the recital of the framework directive I showed to you, but it's also referred to here on page 1048. Towards the bottom of the page, you see the heading Authorisation of Broadcasting Transmission Networks. And in the second paragraph, we see that the new framework is to include all broadcast networks, as well as telecommunications networks, in line with the principle of technological neutrality. And on page 1049, at the top of the page, the licensing of broadcasters, insofar as those licensing provisions relate to regulate the content of transmissions, is not subject to this communication and is not covered by the new regulatory framework. So, in other words, the regulation of broadcasters as content providers, not covered. And then one sees in the following paragraph, in most cases, the operation of broadcast network infrastructure is already undertaken by a separate company. That would be the pure transmission service. Where this is not the case, separate authorisations would in principle be required. So in other words, consistent with the position explained in recital 11 of the European Code, the intention was always that unified service providers should be subject both to regulation as electronic communications service providers and as content providers. And the fact that the content rules apply to the content element of a service doesn't affect that separate and parallel regime applicable to the elements comprising transmission services and networks. And that further confirms the tribunal's approach of considering the transmission elements separately under section 32, subsection 2A. The reference to authorization, I think, needs to be broadly understood in this paragraph. It's really a reference to regulation generally. There is no specific prior authorization requirement under the CRF, but there is, of course, a notification requirement, as Mr. Ward explained. I wonder whether I need to trouble you with the BEREC documents. We say they don't take matters further forward. They simply identify that there is a content exclusion, but we don't think they conclusively assist on the question which is before your lordships and which the tribunal was determining. They simply don't address that question at all. The focus of the OTT communication was precisely on this tech-on-tech examination that Mr. Would arise in a situation where content has already been excluded. And so unless helpful, I don't think I propose to refer further to BEREC if there's a concern. No. On the case law, there are a number of European cases that consider the meaning of Article 2C of the Framework Directive, but none of them is exactly on point. They're all dealing with somewhat different situations. So the Gmail and Skype cases, we say, don't concern content provision at all. They're precisely about that tech-on-tech assessment. Neither of them identifies a content related aspect. Indeed, paragraph 18 of the Gmail judgment, just for your note, on page 1009 of the bundle, notes that the referring court considered that content-related aspects of the service are not important in themselves. And neither of the UPC cases concerned a pay TV provider like Sky, which makes some of its own content. That said, the UPC versus Hilversum case is at least somewhat relevant insofar as it concerns a pay TV company that provided content, albeit that it did not produce any of the content itself. And in my submission, that case is consistent with and supports the tribunal's interpretation. So perhaps if we turn it up briefly, it's in the Authorities Bundle, Volume 4, at tab 36. So the facts of the case are this. It arose out of a request for a preliminary ruling to the Court of Justice by a Dutch court. In brief summary, the company UPC Nederland BV had bought a cable network from a local authority in the city of Hilversum, and a condition of sale was that UPC offer a basic cable package of television and radio channels at a capped price. UPC then sought to increase the price above the cap. That led to litigation. And one of the issues was whether UPC was offering an electronic communications service, with UPC arguing that it was and Hilversum arguing that it wasn't. The Dutch court referred a question about that. You can see that on page 968. Question 1. Does a service consisting of the supply of a basic cable package for the delivery of which both transmission costs and an amount relating to charges for payments made to broadcasters and copyright collecting societies in connection with the transmission of programme content are charged fall within the scope of the new regulatory framework? The European Court addressed that question beginning on page 971. Paragraph 35, it identifies Article 2C of the Framework Directive as the relevant provision. And it sets out that definition in paragraph 36. The court then refers at paragraph 38 to recital 5 in the preamble. providing for separate and parallel regulation. It explains that convergence of telecoms, media and IT sectors means that all transmission networks and services should be covered by a single regulatory framework, and that it's necessary to separate the regulation of transmission from the regulation of content. And in the middle of the paragraph, the NRF does not cover the content of services delivered. And at paragraph 39, reference is made to recital 7 of the Competition Directive, we also looked at. And one sees in the final sentence of the paragraph the statement that the transmission and broadcasting of radio and television programmes should be recognised as an electronic communications service. And over page at paragraph 41, you see the conclusions drawn. It follows from the foregoing that, as the Advocate General observed in point 33 of his opinion, the relevant directives make a clear distinction between the production of content, which involves editorial responsibility, and the transmission of content, which does not entail editorial responsibility. Content and transmission are covered by different measures which pursue their own specific objectives without referring to customers of the services supplied or to the structure of the transmission costs charged to them. So the court approached the question on the basis that content regulation and transmission regulation were pursued under parallel and separate regulatory regimes, with regulation of transmission under the common regulatory framework now extending to the media as well as telecom sectors. And at paragraph 42...
Just before you move on, that
Yes.
paragraph does seem to suggest that when they talk about that and being covered by different measures, they're using content in the sense of production of content, which doesn't entail any editorial responsibility, not, as you say, as extended by 27A, provision of content.
That is, I agree with your Lordship. That is one of the oddities of this judgment, that it appears to overlook the paragraph relating to provision of content, which is clearly and separately specified in the legislation and was at the time of this decision. But I agree that that is not, and your Lordship may have noted in the judgment that below that the tribunal considered that reading the definitions, provision as well as production did appear on its face to be covered, but it recognised that that was apparently somewhat in tension with this paragraph of the Hilversum judgment. I'm not sure one can take it further than that.
This is a 2013 judgment. The code is 2018, isn't it?
It is, but the same
I know.
two limbs are to be found also in the CRF that was in place at the time.
And there's nothing in the Advocate General's opinion that
We
that.
didn't find anything that was illuminating. It may be that my learned friend has spotted something, but it didn't appear to us to assist. But the element of this on which we do place reliance is the very clear separation. I think you have my point about this. This is consistent with the clear separation of regulation of transmission and regulation of content we've seen throughout. And at paragraph 42, the European Court considers the position of UPC. It notes that UPC was not involved in the production of content in the sense of editorial control. But one sees that from paragraph 43 on, UPC was nonetheless involved in the provision of content services. As noted in paragraph 43, the cable package which it supplied involved the provision of content to suppliers over UPC's cable network, and the charges made to consumers included the costs of licensing the content. And the court therefore proceeded to consider whether this, the provision, would take the service outside the definition of ECS and therefore outside the scope of the regulatory scheme applicable to transmission. And the court held that it would not. So picking it up in paragraph 43, the court states that although UPC's customers take out a subscription for the purposes of gaining access to the basic cable package offered by that company, that does not mean that UPC's business, which consists in broadcasting programs produced by content editors, by transmitting those programs, to the connection point of its cable network to its subscribers' homes must be excluded from the definition of electronic communications service within the meaning of Article 2C. So the fact that UPC provides content to its customers does not exclude it from the definition of electronic communications service. Then at paragraph 44, on the contrary, it follows from the observations in paragraphs 36 to 41 above that the provision of a basic cable package falls within the definition of electronic communications service and therefore the substantive scope of the NRF, insofar as that service includes the conveyance of signals on the cable network. So the court's conclusion is that to the extent that the service includes the conveyance of signals, it is within the definition of electronic communications service, notwithstanding that it also involves the provision of content to subscribers. And at paragraph 45, any other interpretation would considerably reduce the scope of the NRF, undermine the effectiveness of its provisions, and therefore compromise the achievement of the objectives of that framework. Since the purpose of the NRF is to establish a genuine internal market for electronic communications, in which those communications must eventually be governed solely by competition law, the exclusion of the activities of an undertaking such as UPC from its scope, on the pretext that it does not restrict itself to conveying signals, would deprive the framework of all meaning. So the fact that UPC does not restrict itself to conveying signals, but also provides content, does not take the transmission element of its service outside the scope of the regulation applicable to transmission. And by the same logic, paragraph 46, the fact that the subscribers pay to cover the cost of providing the content cannot preclude the service being characterised as an electronic communications service. So stepping back, whilst UPC is not identical to Sky in terms of its activities, the court's reasoning, we say, is consistent with the tribunal's approach. UPC, like Sky, provided content, and the court nonetheless proceeded on the basis that insofar as its service included conveyance of signals, that was enough to render it subject to regulation under the new regulatory framework. So, case clearly not directly on point. This is not the situation of Sky, which does produce content, but UPC did provide content, and that was not seen as an objection by the Court of Justice to its qualifying as an ECS. And we say that that in turn is consistent with excluding content services, both provision and production, prior to considering the scope of subsection 2A. So, my lords, to conclude, you have my submission as to the natural reading of the statutory provisions, as to the text of the code, which section 32.2 in its current form is intended to implement, and the underlying objective of bringing the communications or transmission elements of the media sector within a single regulatory framework to apply alongside any separate regulation of content. And you have my submission that that UPC versus Hilversum is at least consistent with the outcome that the tribunal arrived at. Subject to any questions, those I think are all of my submissions.
So, Holmes, thank you very much indeed.
It's been pointed out from behind me that the transcriber hasn't had a break, for which I apologise to the transcriber for this morning. I'm very content to make my reply submissions this afternoon. I know we have till 4:30. It can't possibly take me until then. So
we're confident also.
I'm glad we're aligned on the point.
Shall we start again at 22?
Yes,
The transcriber has it.
That'll be ample. No, it's not. Thank you. Appreciate it.
just so everything's recorded. I mean, there is that warning notice that
Oh, I see.
recording
Oh, I see.
continues throughout.
Thank you for the warning. Let me just think about what I'm doing here while it's quiet.
Yeah.
That's okay. Thank you for reminding me.
Right. Unless the things like that, I don't think we should go back into the main room with the client and have that distraction. I think maybe best if we walk down the corridor and have just a quiet word between ourselves. Do you want to? Is that okay?
Yeah.
Yeah.
Do you want just the three of you?
You're very welcome.
Yeah.
Just let me try and think
Come.
through. I mean, I can come out with you now.
Yeah.
I thought he was obviously short, so it was
Yeah.
Like,
What round the table?
Just so you know, we have to be done by 20 past 4.
I'm confident, my lord, we won't get anywhere near that far. Let's see. Starting then, I'm going to address Mr. Holmes's submissions broadly in the order that he made them. Firstly then, section 32. He said that, correctly construed, broadcast transmission services are very likely to be caught. In reality, they will all be caught on his analysis, because at least in a service like Sky's, everything is either transmission or it is content. And it was conspicuous that Mr. Holmes didn't address the points we made about the move from wholly or partly to wholly or mainly. His analysis reverses that statutory innovation. But then he said, well, if Sky is right, all broadcasting transmission services would be excluded. Because he said, I'm sorry, I'm paraphrasing obviously, that there clearly or obviously will be predominantly content. But of course, I can't say whether that's right or wrong. The only case, there are 2 cases in effect in front of the court. There's Sky, which obviously we submit is predominantly content given its particular characteristics. But then we have the UPC Hilversum case, which I'll go to again shortly, which was held to have been caught because the type of programming it was providing did not take it outside the wholly or mainly test. I'll come to that in a minute. But it is, in my submission, an attempt to win an argument about construction by making broad assertions of fact in what will, in truth, be a multiplicity of cases that need to be looked at on their own facts. And then he said, in fact, it's just useful to have in front of you, because I'm about to make a point slightly more granular detail. Going to Authorities Bundle 1, tab 2, page 19, the definition. He said, he accepted that the except as so far as it is a content service must apply to A, B and C. But of course it does no work in A and B because as implemented by the United Kingdom, neither of those is qualified by some sort of threshold condition. So of necessity, the Internet Access Service will qualify within the definition of ECS. The proposed interpretation where you take out the content before applying it is at best pointless, but actually the content exception operates in precisely the way that Sky submits, namely to say that this ECS regulation cannot extend to the content.
But why is it pointless? If you can have an internet access service, which you suggested could have some content, for example, a web page, why doesn't the wording, except so far as it's a content service, make clear that you're not regulating the content aspect?
My lord, that's exactly
an IAS.
That's exactly our submission.
So it is doing some work.
Sorry, it is.
It is doing some work.
Yes, so sorry. Forgive me for interrupting. I agree wholeheartedly with what your lordship said. The point I'm making is a different one, which is it makes no sense to say that somehow has to be applied before the concept Internet Access Service is considered to see whether the service is of a type that falls within Section 2.
Well, it's neutral. It doesn't make any difference whether you do it before or after.
Or redundant, one might say, on this analysis.
Right.
So it's also conspicuous that having made these broad assertions about how the regime will apply one way or the other, Mr. Holmes also had a go at saying it's all a terribly difficult judgment, but I'm sorry, in the hackneyed phrase that is familiar from the bar, one can't have it both ways. And what we say instead is it's just a fact-sensitive question. And he criticised Sky's argument for treating the service it provides as he put it, an indissoluble whole, But we are unrepentant about that. That is indeed the service provided. It is indeed common ground. It is a unified service, which just means it's not a bundle. And one looks at it as a whole, what the consumer receives, and say, what's the predominant feature? We don't accept there's anything particularly difficult about that. Then he said that on Sky's analysis... Sorry, Mark.
If you take a service which only provides third-party content, what is the predominant feature? Content or signals?
It depends on the facts. When we look at UPC Hilversum in a minute, what you'll see is all it was doing was rebroadcasting free-to-air services. So in the UK, at least, that would be Freeview, if you're familiar with that, my lord. And in that situation, one can see that the transmission service isn't adding much value. But that may be at one end of the spectrum. Sky's premium channels may be at the other end of the spectrum. Other services may have different combinations.
So if you hypothetically had a broadcaster who brought in Sky's channels, just Sky's channels, and broadcast those, what would you say the answer is?
So it just depends on the facts. So we've been
I've just given you some facts.
Yes, well, all right, but it would depend on an assessment by the regulator as to exactly what was being offered and on what terms. But if what was being offered was a bundle, a large bundle of Sky's premium channels, then it may well be that you would say that the content was the predominant purpose.
A number of submissions have been made about the perspective from which one should conduct this evaluation. And points have been made, you look at it from the consumer's point of view. Not many consumers faced with any content package are going to say, really, really interested in the way this was transported to me. They're going to say, I want this, I want that channel.
And they may not know what comes over the top, what comes by satellite.
They may be indifferent to it.
Or indifferent.
And that's the whole point about technological neutrality.
My lord, it is.
So in terms of that evaluation, actually, if you put the consumer into the equation, the answer might be quite clear in most cases.
Well, it rather depends. I mean, supposing one had a different example where what's being provided is a connection and the only content being provided is some local news channel, but the connection is also usable for something else. It might not be, it might be caught, just like Hilversum is. I know I'm guilty of being evasive here, but I'm trying to evade on the basis that it is fact sensitive and it is for my friends over there to decide. So the next thing Mr. Holmes said was that on Sky's case, we say that the content regulation trumps ECS regulation. And we don't accept that at all. All we say is the service as a whole has to be looked at when one decides what it wholly or mainly is. That's not a question of trumping, it's just evaluation. Then we get to the EECC, Article 2.4, where Mr. Holmes made a point on the order of the words in Article 2.4. And he also made, in his very polite way, a suggestion that this was something I had skated over. But we didn't address it for two reasons. One, no such point was made in Ofcom's skeleton that we could detect. But also, because Parliament did not implement this provision in the order of those words, and moreover, it's common ground that the changes Parliament did make because of the EECC made no difference. And we respectfully submit that that is indeed right. Now, he also said, well, that there was something wrong with our argument because on Sky's argument, an ECS could, in fact, include content. So we may have an ECS, but it still may have content. And that I think that there was something, if I understood his point correctly, he was saying we were somehow blurring the boundaries of these two separate regulatory regimes. But of course, that's true whether Sky is right or Ofcom is right. This service that may include content and transmission elements may indeed, as he says, fall to be regulated under both regimes. In his analysis, it's always going to happen because the ECS is going to be triggered by the presence of transmission with all of the content disregarded. So yes, as he says, all broadcast transmission networks will be in. Insofar as they involve content, that content will fall to be regulated under content regulation. But the very risk that the legislator is alive to arises squarely, which is you have a mixed service and there is a risk of the content being regulated under the ECS, which it was astute to prevent. On Sky's analysis, that problem only arises if the wholly or mainly threshold is crossed. In our respectful submission, that makes far more sense of the legislative intent. What Mr. Holmes did was to go to various recitals, which say in various ways that the same service can be both, or that broadcast transmission falls within the scope of the regulation. Indeed, it does. I showed the court that it used not to in 1990. That was a change. No question, the common regulatory framework makes that clear, but it's subject to wholly or mainly. And really importantly, it remains subject to wholly or mainly in the EECC, despite the fact that it has split out various other services to which wholly or mainly does not apply. Then we get to the 1999 review. Again, if I may, I'll just turn that up briefly. That's tab 41 in Authorities Bundle 4. If we go to page 1033, please. Mr. Holmes made the point, it was a variant of the same point he made a number of times. Look, it refers to broadcast networks and services. We agree. And it says the content is outside scope. You can see that from the first box. We agree. But what he didn't grapple with at all is at page 1040, which is the point I made in opening my case. It doesn't include the content exemption. But according to Mr. Holmes, it's the content exception, that is used to overcome a wholly or mainly test, which he said in his submissions would otherwise take most broadcasting networks outside. That's the difficulty he has. All the work is done by wording that just isn't there. And I also observe another matter that Mr. Holmes didn't deal with in my submissions. I said after I'd developed my case on the framework directive that there were three consequences of Ofcom's argument, and I'll just remind you, they weren't dealt with. Firstly, that it was the content exception itself that caused the broadcasting transmission service to be regulated. That's really the point I've just made. Secondly, it's only because it's content that the service is dismantled and brought in, even though the point of the content exception is to keep things out. And then thirdly, the legislation moved from wholly or partly to wholly or mainly, and Mr. Holmes's analysis reverses that. And then finally, I'll go, if I may, to UPC Netherlands, which is Authorities Bundle 4 under tab 36. But actually, I want to start at 35, which is the Advocate General's opinion. And Mr. Holmes accepted when he opened this case that it wasn't really on point, but he said it's nevertheless consistent with Ofcom's analysis. It's just worth seeing at 951, please, just the fact and what the issue is. This is in the Advocate General's opinion, tab 35, page 951. The first question from the referring court is whether a service consistent in the supply of free-to-air RTV package via cable falls within the scope. So that was what was actually on offer. It couldn't be more different from what Sky has. And then in the next paragraph, it tells you what the dispute was. It was paradoxical, really. UPC was claiming it supplied an ECS, so it was regulated, but it wanted to be regulated to stop the local authority from interfering with its tariff because it's a harmonised framework. And the government was saying, no, it's content, so it's outside scope. And the court, of course, sided with UPC. And I'd have to concede its judgment isn't the model of clarity, but I will submit it provides no assistance to Mr. Holmes. So we see at 971 in paragraph 36, the court refers to the wholly or mainly test in the third paragraph. And then it says at 42, it is apparent that the principal business is the transmission. And that's, of course, a proxy for the wholly or mainly test. Indeed, it's not very different from the UK implementation. And then it says the point that my Lord Justice Popplewell has alighted on, that it says it does not produce the programmes and does not exercise editorial responsibility. So the first thing is, it's obviously not applying the content exception. It's saying the content exception is irrelevant because it's not falling within it. But it does find that provide means produce, if you like, not quite in those words. So it's taking a view of provision that is more active than merely reselling CNN's channel. Fact sensitive. Mr. Holmes says he doesn't agree, but it is, of course, a bit awkward that this is a finding of the European Court on the Common Regulatory Framework, which is itself the basis for the legislation. So it's not suggested that this court should depart from it under its limited powers to do so. But importantly, I fully accept it. Of course, at 44, it uses the words include, at 44, Mr. Holmes relies on. But then again, at 47, it goes back to its analysis in 42 and says, it says, having regard to all these considerations, the answer is that, so I'm trying to find a way of skimming it without being confusing. Article 2C of the directive must be interpreted as meaning a service consisting in supply of a basic cable package, which includes a charge for transmission and payments to broadcasters, etc. And then the fourth line, that's the fifth line to pick it up, falls within the definition and consequently within the scope of the directive and of the specific directives constituting the NRF, meaning New Regulatory Framework, CRF, applicable to electronic communication services insofar as the service entails primarily transmission. And indeed, that word primarily transmission, those words appear in the dispositif on page 975, which is the bottom of the first of the grounds of dismissal. So in our respectful submission, seen correctly, this is just the wholly or mainly test in action. And unless I can assist the court further, those are our submissions in reply.
Well, thank you very much indeed.
Thank you, Alan.
Well, we'll all have a lie-in tomorrow morning. Can we thank everybody for their written and their oral submissions, which we're extremely grateful for. And we extend our thanks, of course, to those behind. We know how much work all the teams do in cases such as this. We will reserve judgment given where we are in July. There will be no judgment sent out before the end of term for the vacation statements. Draft judgment, when it comes out, will be in draft for editorial review only. Please ensure that the confidentiality warning on the front of judgment is complied with, and in due course we would be grateful for a draft order agreed as far as possible. And if there is disagreement, we'll deal with it on the papers. Thank you all very much indeed. We wish you a very good vacation.
Thank you, Alan.
Court rises able.